you all know as well. We appreciate this opportunity to come in here and just communicate with you and tell you a little bit about what we do. And what I would like to emphasize is that this is your time, so please feel free to bounce questions to us. We will probably cover a topic and then give questions time and then cover the next topic. So Karen and I have known each other for a very long time, so we're having a little fun with this because I'm going to sell Karen a house. And since I've known her forever, she doesn't need anything, right?
I don't need title insurance. I've known her forever.
Wait a minute, you guys are.
Tim have known that have had the house for forever. So what do we need?
What's the problem? Okay, have you guys ever heard that? Yes, we have heard it a lot.
Every day.
But the purpose of title insurance is not to say, hey, you're friends and everything's okay. What we do is we look and see what is at the courthouse that has been recorded and filed. And that's what our research is based on. So that we make sure that what is on paper at the courthouse matches what you find out from your clients. So we were asked to talk about, well, what is at the courthouse? What do we look at to decide what people own and how they own it? So those documents you're familiar with, you've had it in title school, in real estate school. So the best document we rely on and we like to rely on is called a warranty deed. So all of you have seen a warranty deed in your lives, correct? Okay. So a warranty, and I'm not an attorney, my husband's the attorney, so I'm going to qualify that. I'm not giving legal advice, okay? So, but a warranty deed does just that. It warrants and guarantees that what you are selling and the people that are signing have the right to convey this property free and clear of liens. And title standards look for that to make your ownership marketable. Now that's a legal term, but that's the term you all like, because if it's marketable, that means I can buy it today and sell it or 5 minutes or 3 seconds later. Okay. So that is what we look for, is the warranty deed. And then hopefully those warranty deeds go back, and title standards say a minimum of 45 years. And that is called your chain of title. So if I own it, so we have a contract now. Chris Cisar is selling a house to Karen Wiedenmann. So what do you think I'm going to look for in the title records to make sure that Chris Cisar can sell this to Karen? Yes? That I own it. All right. Now, look on this document here. This is your commitment for title insurance, right? So I've signed the contract. Chris Cisar selling house to Karen. And now you're going to skip the top part, which is the little, basically what Stewart Title requires us to have.
It's called a jacket.
It's not a jacket anymore. Now it's just printed paper. It used to actually be a jacket. And you're going to look for something that says Schedule A. So that's basically the 4th page here. All right, is everybody with me? Looks like this. Yeah, looks like this. Okay. So on your Schedule A, what you will see at the top, commitment date. Now notice that is not today's date? Does anybody know why that is not today's date? Besides Carol. Good guess, but no. Is it before or after today's date? It's March, right? It is the date that the search that was conducted at the courthouse is valid to. And notice that will always be a lag time between that date and your closing date. Now, we try to make sure that lag date, we internally update that to the day of closing. We don't necessarily send it back out. You will see what's called an update for banks, where they say, hey, we have to have it within 30 days, which I would recommend is your commitment should be within 30 days. Okay.
And we're doing that behind the scenes, whether you don't necessarily need to ask for it. We're not going to send it out, but we have checked it.
We check it
most
internally.
recent point that we can right before closing.
Okay, but now you know why that date is always going to, because sometimes you ask, well, your commitment date is earlier than even the contract date. Yes, that happens too.
Because the courthouse records may not be up to date to where we are.
All right, then it says proposed insured. That should be the name of your buyer and how they want to buy it. So Karen, how do you want to buy this property?
I'm going to put it in my trust.
Ah, Karen has a trust. So what happens with that proposed insured? We'll need to change it. How is it going to change?
We're going to add the name of the trust.
Okay.
And this is very important because lenders look at that. So if you write the contract and they don't say anything about how they want to take title, or they don't know yet, we'll need to change that if you find out later that they do want to put it in an LLC or a trust, because when we send this to a lender, if there's a lender involved, they're going to look at that, and if it doesn't match the contract, or if the lender doesn't want it to be doesn't want to do the loan in a trust name or an LLC name, they're going to see that name and think, okay, we're good. But then at the last minute, everybody's changing it to a trust or an LLC, and then that throws a problem for the lender. So, because they rely on this name to match the contract, the title commitment, and their loan, they all have to match. And depending on how you're going to own it, there might be different requirements for those things. Not necessarily. If it's an LLC or an entity, we do check names for liens, judgments, things like that, bankruptcies. So we have to then run that name to see if there's anything that pops up under that.
Carol, we have a lot of people who want to join. If somebody can let them in. I will let you. Yeah, I'll let you do that because I don't want to do that. Perfect.
Okay.
Thank you. All right. Yeah. Okay, everybody with us so far? Yes.
Well, for the buyer, on the buyer, we rely on you guys to tell us, or the customer to tell us. A lot of times, the customer is telling us, oh, by the way, I'm going to put this in my trust. I want to take title in my trust. You guys don't know about it. The lender doesn't know about it. So then we're scrambling and we're calling you guys and saying, hey, they want to put it in their trust. We'll need an amendment. So Carol doesn't get mad at you or Lori or any of the admins. We don't, yeah, we take the name off of the contract. So however you put the name on the contract, that's how we're gonna put it on there until we're told differently. So a lot of times the lenders will say, oh, we need to add their middle initials or take their middle initials out or whatever. You know, there's any number of variations that we get. And we'll change it when we know, but at the end, at some point, you guys are gonna want for your office and for the auditors, you're gonna want that all to match. But we take it off the contract. Most of the upfront information we get is off of your contract that you give us. So if it's wrong on the contract, then we're gonna have it wrong. And we all know how happy people are when we don't have it right. So.
What about people that want to say no LLC and there's no LLC created yet? What? I don't know if any side.
Well, they have to create it first.
Obviously.
So as long as they create it before closing and it's registered, yeah, because we do check that. And if there's a lender involved, it's going to have to be legally created. So now we highly recommend and we require operating agreements. So I always tell people when that question comes up, because we get a lot of questions about that. We think we want to form an LLC. I'm like, okay, well, first check your name at the Secretary of State's office, make sure it's available, because they're not always available. Somebody else might have it. So, and then I'm like, make sure you get it formed and please have an operating agreement because you're going to need that. Even if it's a single member LLC, they still need, it doesn't have to be a fancy document, but they still need an operating agreement. Because that's what we rely on to say they have the authority to sign and that.
And some people ask, well, why do I even need it if I'm the only member? I'm authorizing myself, right? Well, is the single member married? And then what if the single member dies? What your operating agreement should do is cover those areas. I know. So, but that
broad shoulders.
those are conversations. Operating agreements need to come through legal counsels. Title companies cannot prepare those for you. Okay, that is not something we can do for you.
Well, yeah, you can do them online.
And you can do them online, and you get what you pay for. But that's
it's all fine and good as long as everybody's alive and well and nobody's fighting with anybody. But then the second somebody dies, and then you have a property that's vested in an entity that nobody knows what you can do with because there's no documentation. So then it's fun.
Yeah. All right. Next to Karen's name on the right side is a policy amount. What is that supposed to be or match? Hopefully. That's lower down, one higher up, the 350,000. What is that represent? That should match your sales price. Okay, when you are looking these over, those should match your sales price.
If you have to see one that's wrong, it might be because we couldn't read an amendment or something,
right?
Or we just missed it, or because we don't have the amendment or something. So right. If you see that doesn't match, that's a good time to say, hey, the sales price doesn't match. And we can look at it and say, oh, yeah, there is an amendment. We just missed it or whatever. So, or a counter offer.
Or we got lost in the counter offers somewhere.
Or they couldn't, it was hard to read or, you know.
Now, y'all know Karen real well. What happens if Karen is married?
Not gonna happen.
Let's pretend Karen is married. So we'll say Karen Wiedenmann, a married person. Now, if she's buying it cash, it doesn't matter. But in this case, Karen is getting a loan with her favorite local lender. What does that trigger to you, if anything? There's the good, and I see one say both husband and wife have to be on there, and I see a head shaking no. So one to buy, two to sell. But, go.
With the lender, the husband or wife would have to join on the deed of trust, or they'd have to sign something, be it a marital waiver, which we don't really like, but that's a big part of this. But they either have to sign a marital waiver or they have to sign the deed of trust. So the spouse, even though if they're not going in title, they have to sign something that has to be recorded. So that's why we always say, are they both going to be here? They both need to sign, otherwise we have to make arrangements.
Now I'm going to qualify that, okay? Different underwriters have different standards. This is the one time, not the one time. This is a good example where underwriting standards between different title underwriters, not companies necessarily, underwriters, differ in their approach, okay? There is a case out there, it's called Etheridge. It's which started all this marital interest problems in the state of Missouri. What happened was, guy refinances the house, the wife signs, but her name isn't on the document. She actually signs on it, okay? The court held that because nobody knew why she was signing this document, they threw out the deed of trust as being invalid. So, and property was vested in his name only, but they said, nope, we're throwing it out. We don't know why she signed. And she says, well, he died and I don't have to pay this. And the court held it true. She did not have to pay it. Now, that's what makes title companies squirm, stuff like that, okay? And that's why underwriting standards are different. The one time title companies can consider not requiring the spouse to sign on a deed of trust is a purchase money deed of trust, which means like this, where we know that the other side has absolutely no financial interest in the property. Now, that's a high standard to get to. And that's why it's easier just to be prepared that the spouse will need to sign something at closing and be available. So your client, prepare your client that it's okay when they say, I don't want to tell you who I'm married to. That we need to get past that. Okay.
We're not being nosy. We're not trying to, put the spouse on title if they don't want it that way. But there most likely is going to be something that the spouse has to sign for closing.
And different lenders have different standards on that as well for that reason. Yeah.
Well, like, what if they had a joint checking account that their earnest money came out of? The spouse does have a financial interest in the house. So yeah, but there could be so many.
It's a very high standard to get to.
That's why we don't like to go down that rabbit hole.
I mean, you really have to say, and you have people who have completely separate accounts, completely separate lives, where it would all
work, probably would
but
bear it out that way.
We don't want to have to get to either judge or jury on that. That's the point. Okay. So that's why we try to stay away from that.
That's why we try and say, plan on them having to sign something.
Yeah.
The husband put the loan in his name and then just quit claim deed his wife onto it at closing.
Okay. So sometimes your lender will dictate, and you'll have that in a VA loan or special circumstances where they say, look, the only one qualified for here, okay, Karen is married. She doesn't qualify for the loan. We have to put it in his name. Okay. Now Karen's not real happy, but and it's like, well, you shouldn't have gone gambling. All right. So she's got gambling debts, and so the bank says, no, we can't put her on title.
No, I bought Bitcoin and I can't.
Oh, Bitcoin.
can't prove that I have cryptocurrency. That's what it is.
All right, so then we have to follow the lender's wishes in order for the loan to be available. And that's another different ballpark. And then we just wait for the lender to tell us what do we need.
Another scenario that you can have is you can't, for and again, it depends on the lender, but you can have both people in title with only one being on the loan. Now, again, some lenders, if it's a VA loan or an FA, certain types of government loans, they may be a little pickier about that. But most of the time for a conventional loan with most lenders, the husband and wife can take title together, even if only one of them is on the loan. The spouse is just going to sign the same documents, certain documents. She won't sign everything, or he, whichever way it goes. But so you can put them both on title, or you can deed a spouse onto title after the fact. We
To
just have
answer
to.
your question, yes, it can be done after closing as well. So, and most lenders, what you do the day after closing, you sign it. You have to complete the transaction. So you sign everything, you sign your loan, and then you sign your quitclaim deed, even if it's 5 minutes later, okay? The crucial part is how it gets recorded at the courthouse. So hopefully your friendly title company puts that in the right order, doesn't record it in the wrong order, which will screw things up, okay? So we usually bow to the wishes of the lender if they have a concern. And that's who dictates that. And when we ask for 3 different amendments, that's why. Because the lender won't do the loan unless we do this. And we usually go, okay, right.
Yeah, it's not usually us coming up with all this crazy stuff.
Yeah.
Well, we come up with crazy stuff, but
yeah,
a lot of times.
So that's on the buyer side. Now, let's turn to the seller side. Look at paragraph 4 on that page. This is how title is vested at the courthouse as of the date of this commitment, which is March 15th. What do you notice there? Who owns this property? Well, who is that? The seller on your contract is Cisar. So that you need to pay attention to, okay? So if Christine A. Cisar signed your contract and your commitment comes out and it shows title is vested in anybody other than who signed your contract, we need to say boo, and we need to clear that up quickly.
So we know who's really selling the property.
Right, because they're on trust, that's when you find out the decision,
Okay.
contract's been a trust.
Yeah.
Okay.
Yeah, exactly.
So this we find recorded at the courthouse, okay? That is not an unusual scenario where you don't know that the property has been transferred to a trust, to an LLC, or even to the kid. Hopefully that's not the case, okay? Right.
Yeah, the child and their spouse would have to sign at
it.
closing.
Hopefully the child's not a minor. Okay. So now Mr. Listing Agent goes, we better find out what Duloc Properties is. So you pick up the phone and you call the friendly seller. Who wants to be my listing agent? I need a volunteer here. All right. Ethan, call me. What are you going to ask me?
Oh.
No.
Yeah, he missed.
Okay.
That's why we
Ethan,
picked on you.
that's why I picked on. Ethan is gonna call Miss Christine Cisar and say, hey, you're selling that house to Karen. I said, yeah. We got the title commitment and it shows Duloc Properties. What is that? Oh, that's my husband's LLC. What's your next question?
You have an operating agreement.
All of the above.
Mrs. Cisar, do you mind getting us the documentation on that? We really need the operating agreement. We need to see who has authority to sign. Okay, so that's what you'll be asking for. And usually we actually do that for you a lot of times, but just so you know what that entails. Now, what does that mean to your contract? You no longer have, now, your step one is, what if Chris Cisar doesn't have anything to do with this operating, with this LLC? Who are you gonna find to sign this contract instead of Chris Cisar? Yeah, whoever has the authority under the operating. Okay, for kicks, we're gonna assume this is Tim Cisar's LLC. Okay, so Tim, you get the operating agreement, and Chris Cisar doesn't show up anywhere. Okay, it's Tim Cisar. All righty, let's turn the page. Okay. The next section, depending on which title company you have, is usually going to be either one or two sections. In our case, we use two sections. One lists the requirements, and then the second section lists your exceptions. Some title companies actually combine that into one section where your requirements flow into your exceptions. Okay? We do divide them up. So requirements is basically our evaluation of this is what we're going to look for to be able to close this transaction.
All of these requirements in order to do everything.
So the first four are standard on every commitment, and they're pretty standard for anybody. One is that, you know, you need to let us know who has an interest. You have to let us know who's paying for what, etc. Paragraph 4, then indented, you're going to get what is specific for this transaction.
Yeah. The things we do at closing usually.
And you don't really need to know this, except you need to look for anything that is going to be unusual. So typically, it's going to require your warranty deed, your deed of trust, and those two are if it has a loan, okay? That's as basic as it gets. A warranty deed, you need on everything. A deed of trust if you have a loan. But we have a list of 5 things here. 6 things. Okay, I got it. So what does the first one say? Secure and have recorded. And go up to A, 4A. Secure and have recorded notice of intended sale. What?
You know what that says to us? New construction. It's like, oh,
Right.
We need stuff.
So what does that trigger? Okay, a notice of intended sale. Does everybody know what that is? You don't. This is what you file, hopefully, if you have a brand new house that has never been lived in or has been remodeled and is not currently lived in. And it is the builder selling it, basically, or a flipper or somebody.
Yeah, flipper, yeah, a
I
remodel.
did not know that.
Yeah,
If they're
remodels.
doing substantial, I mean, if they're just painting, I mean, but if they're,
Yes.
They bought it.
If they bought it,
really rehab
rehabbed
it.
it,
knock down wall, I mean, really,
yes,
Okay.
you know.
it qualifies.
Is there like a
The occupancy is, it should not, it will involve it if the person living in it, if it's their primary resident, you don't need it. It doesn't qualify anymore. Okay, right.
Brand new.
You have to have a certificate on it from the city or county.
We like to see it.
And a lot of times
The lender
will
will,
require it.
the lender like wants it.
Yeah, if it's a total gut job and they're putting 20, 30, 40, 50, or how many ever dollars into it, that's pretty substantial. So
Right.
that's,
Do you guys know the time frame in which that should have been recorded before sale? 45 days, okay? For a
At least.
minimum of 45 days on record, that's recorded 45 days, okay? And then your builder is supposed to put one at the job site also.
Do you require
Yes. We'll get there in just a minute. Yep, we require both.
So, Chris,
Not-
do you-
Yes,
You guys file those for a builder if we have a contract?
Yes.
And you guys will do that for them? Okay. Then you
Yes.
charge them.
yes,
yeah, it's just the recording fee.
right. We just charge it at the end. All righty.
But if you see that on something, or if maybe you didn't know that it was, you know, if it's been more than a year when they've rehabbed it, then that's,
Right,
don't worry about it, but.
yeah. So the question is, how long? Well, if your construction is over a year old, you don't have to worry about it. If it is between 12 months and 6 months, we would look at it if it's, we would record it if we have time. If we don't have time, we'll take a look at it. If it's less than 6 months, you pretty much have to have it.
Okay.
Okay, so keep that in mind if you have a listing on a new construction, which there's a lot more of those going on right now. So make sure that that's been recorded, and if it isn't, it could affect your timeline.
Yeah, just call your title, just call us and we'll look and see if there is one recorded. Because maybe they knew to do it and did it and you don't know that they did it.
Yep. Now, B is the warranty deed. C is the deed of trust. Karen takes out the loan. D, secure and have recorded release of deeds of trust. So that is going to show what loans are currently outstanding on this property. And it will list those. In our case, it'll list them again on the end. Sometimes you'll see those just listed there, depending on who your title company is.
So if your seller says to you, oh, I don't have any loans on the property, I don't have any payoffs.
I
But
don't
then
have
you-
any loans or payoffs.
No, you told me you didn't
I
have any
didn't.
loans.
But they're Tim's loans.
That's right, she didn't know about them.
Come out and didn't tell me.
So that's where we go. We need payoff information from the seller. Oh, the seller said they don't have any loans. Well, maybe they paid off their loan, but it never got released. So we still have to track down a release because it's still a lien on the property from whenever there was a loan.
Sometimes it happens that we need to track down a release from a previous owner. Those are always a lot of fun. I don't know if you make a habit of asking when you take a listing if your client has an existing title policy. Those are gold mines. Ask them if you can get a copy of that. The reason for that is that if a question comes up at all, that title policy is your best defense to clean it up. We, amongst the major underwriters, actually have agreements where we can accept each other's work without any further requirement. So ask for those title policies up front if you can get them. Also, when you ask for, well, is there a well agreement or a subject agreement or restrictions or whatever, guess what? That title policy, if you have it, it'll tell you what they are. You'll have it right in front of your nose, and you just have to get copies from your friendly title company who'll give those to you. Okay? Those are gold mines, so ask for them. All right, then F says secure and have recorded release of an assessment lien. Oh, Four Seasons, I hate Four Seasons. I never pay their assessments. I've been fighting with them for years. That's right. I don't like my dog. That's actually true. All right, so that means we also have to deal with some sort of payoff on a lien other than just a mortgage. The bigger ones you could be looking for there is there a federal tax lien? And if you have a federal tax lien, again, those are doable unless they're humongous, but it just takes time, okay? All of these things, as we're rushing to get things to closing quicker and quicker, guess what? When something like this comes up, it affects your timeline to be able to get the information needed to cure that. So that's why you want to be looking at these commitments and say, is this going to affect my closing date? That is your biggest question in this. How much time do we need to get this resolved? And how cooperative is my client going to be in getting it done? Because that's really the key also. Have them prepared. Hey, you know, we're not the bad guys. We're here to try to get your property sold. So we need you to help us get that done. And
I mean, we facilitate getting stuff taken care of, but we need your help sometimes. And if you see something on here as, you know, kind of like, oh, hey, I didn't realize that was on there. You know, if you can help us get what we need to clear it up, that's why, you know, we're always, I need your help, you know, because a lot of times we call people and we say, okay, there's this out there. Well, sometimes people get defensive. I don't have a lien on the property. Well, you do. It's recorded. I can send you a copy of it, you know. So that's why we're not trying to dump stuff off on anybody. Sometimes we just need help. And so when we send this out and you see that on there, it can help you prepare the people to help all of us get it done, because it's not going to just go away unless we take care of it.
all right, everybody with us? Okay, any questions? Okay, we're going to finish this section and then we'll make sure we're on the same page. Now, paragraph 7 in here.
5 and 6 are just standard. They're just talking about taxes assessments. And then we'll take care of number 5 at closing. So
Number 7 is your articles of organization, operating, etc. So those are going to be requirements because our seller happens to be an LLC. So yes, we have to have those documentations from your clients in order to do this. All right. Now, look at paragraph, okay, 8, joinder of spouse. And we've talked about that, okay, already. Does the spouse need to sign or not? Okay. So All right, let's turn the page. All right, Karen, read that for us.
The title company notes petition for dissolution filed in Circuit Court of Camden County, case number blah, 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 styled Christine A. Cisar versus Timothy R. Cisar. That's not necessarily a good thing.
And that is made up.
This is-
Okay.
There is no scandal going on here, okay?
I was just making sure you're paying attention.
Dissolution, divorce. And remember, this is titled in Tim's LLC, but we think Chris is selling it. Uh-oh. Yeah, that might not be a good, a good phone call to have to make.
This is where I go, well, that SOB gave me 6 kids and left me. All right. The reason this is shown as a notation now, if you notice, it is a petition of dissolution. If it is a petition, that means it's still ongoing. It hasn't been settled yet. Okay? If it is a judgment, it's been settled and we can go to the courthouse and we can get a copy of it in most cases. Although there is a big push that divorces are being withdrawn from public records. So it is getting harder and harder to get, because a client can say, I don't even want it shown that I've got divorced. And they will redact it out of the records. So we wouldn't even know that the divorce exists, which is scary for us. Okay? So, bingo. Okay, so we rely on the information from the seller to tell us the truth, which is also scary, right? So, but
Petitions filed in another state, you wouldn't necessarily go look for it, right?
we would not know it. The only way we know it is if it's filed in the county that the property is located.
They're in St. Louis. They filed in St. Louis.
Right. We could find it once we know it exists. Okay, we can't, but we cannot find it if we don't know that it exists.
And for all of you who've been in closings with me, with your sellers, you see me go through the affidavit with them. That's the one where I ask them all the questions. I tell them they don't have to, you know, it's not a test, not to be nervous, but one of the questions on there, and this is a sworn affidavit, it's a legal affidavit that can be used in court. It says, has there been any changes to your marital status since you've owned the property? So if they say yes to that, or if they hesitate, or, well, you know, I mean, that's what we're talking about, that kind of stuff, because we want to make sure there isn't a spouse out there that may have a marital interest in the property, because our job is to extinguish any idea that there's a marital interest in the property. That's why we want spouses to sign. That's why we want to know about it, because we need to make sure that they don't have an interest. Doesn't mean they own it, but they might have a marital interest in it. State of Missouri.
Yeah, and that is state of Missouri. And so you're dealing with a lot of clients from out of state where that doesn't exist at all. Okay. So state of California doesn't have this. Illinois doesn't have this. So you don't have to go very far because they'll say, well, they didn't have anything to do with this property. You've probably heard that one. In Missouri, that is a different standard than in other states. So
I always tell them, we're not saying that the spouse owns it. They're not necessarily entitled to the money. We just might need something signed, or we need the divorce decree or something to show that this property is yours.
right. The next section survey coverage deals with your loan policy. Every standard loan, so non-commercial loan, is going to require survey coverage for the lender. And the reason I'm bringing this up is that it does not protect your buyer. We used to get surveys a lot, many moons ago. Then we got no surveys. I see kind of a trend, maybe more that, hey, maybe a survey isn't that bad of an idea. So just know that title insurance does not insure the buyer that the house is not over the line or that the driveway is on their property. That's a misconception. We do not insure that to the buyer. Okay. The only one, because we look at paper at the courthouse, we don't physically go out to the house.
A survey is on the ground as it actually is on the ground. We're looking at paper. So those two aren't the same thing.
We used to laugh at what the GIS looked like as far as how far off it was on the lines, but it has gotten much better. Okay, it's not a survey. It's not meant to be a survey. But if you see an obvious problem on the GIS, I would at least not ignore it. Okay. All right. Any questions on surveys?
So there could be encroachments, you don't know about them, and they might not find out about it until after they bought the house.
Correct. Without the survey, correct. Because I know you guys go through it and ask if your client wants a survey. And I know that puts you in this bag because the first thing they're going to ask is, well, do you think I should get one? Right? So how do you answer that?
It's a house in Four Seasons.
Yeah. So, those are, use the tools available to you. And the GIS has gotten a lot better, And if you're out there and go, gee, this it's like it's awfully tight, you guys are good at that. You're good at judging that. But you also know your buyer, and if they're nervous, the cost of the survey and for the peace of mind is worth it in many cases. All right, 11, we asked about, well, we decided I built a brand new house to sell to Karen. I didn't tell Tim I built the house, but I built this house. So now we know we have the notice of sale. We have that filed. Does that mean I don't need anything anymore? I can just rely on it, and I don't need anything from the builder. Well, we take the position that that's not the case. We still go through the accounting on the new construction, and we have the builder provide us with a list of their subcontractors and providers of materials. Not everyone does that. Okay, I know some title companies will just rely on what the notice of sale, won't call anybody. We do call the subcontractors and make sure that it's paid. We do not necessarily need every lien waiver ever created for the project, which is what you were asking, Carol. We will take whatever information we get. We rely, we primarily make the calls directly to the suppliers to make sure that they have been paid.
Most of the time they're like, oh yeah, they pay. They always
Yeah.
pay. Most of the time it's, no big deal, but every once in a while there's a surprise.
And it was, I don't know, it's getting more now that may become more of a concern again. For a while there, there was no new construction, so we didn't have that much to do. But new construction is really starting back up a lot, so we'll see that more and more to be sensitive to that. All right. Paragraph 12, we'll hit it just real quick. Your lenders have specific requirements to title companies on what they want to see. So I just thought I'd show you that paragraph 12 all deals with what lenders want to see. They may ask, for a 24-month chain of title. What is that? Well, that's basically telling them what's happened in the property for the last 24 months. They want a tax certificate. Well, that's just simply telling them how much the taxes are in their format rather than another format. So a lot of the things that show up on the commitments are specifically because the lender wants it that way. Okay. All right. That ends the requirements at this point. What questions do you have so far? Let's just take a breather. Anybody? Yeah. Uh-huh. Uh-huh.
I do all cosmetic work, no structural, anything. I do all the work myself. You still have to do those.
My thinking on that is do it because it never hurts you to have it if it's not needed. Okay. So the thing with, you got materials from somewhere. If you're doing, remodeling to that extent, if all you're doing is painting and stuff, well, you still had to buy the paint somewhere. That is still considered part of provider and lienable. Okay. No, it is not new. It's been around for a long time. Now, I mean, unless you think 10 years is new. Yes. No, you
Do it at the beginning.
you do that.
When you start.
Now, the thing is, some companies have you file it before you've even touched the ground. That's too early. Okay. On a construction, mine is, think about it, you have to have it on file for 45 days. So you want to do it early enough to say, okay, when am I going to be done where I can sell it within 45 days? Okay, so that you should have it filed 45 days before you're done where you can sell it. Does that help? And if it's a new construction, I usually say, put it up when you frame, okay? But that's usually a pretty good thing, time frame. Good question.
What after the closing buyer claims that the square footage was wrong and they want to sue?
Call a lawyer, honestly.
They did.
That's, yeah.
But I mean, there's no way title's gonna cover that.
No, square footage is not, I mean, we're talking about the square footage on the house, correct? Yeah, the title insurance does not insure square footage. It doesn't insure acreage. It does not insure area, even on how much ground lakefront you got, how much, none of that is covered by title insurance. Okay. As far as the square footage not being what they, what you're talking about is a contract dispute, obviously. And yeah, your friendly attorneys are not your enemies. They are here to provide a service for you. So what it teaches us is to be careful not to promise something that isn't there. And I know that you guys, I think they even changed the law to give you guys some protection against people claiming, hey, you told me it was going to be this much, but it's really this much, depending on what information you relied on, such as the GIS or dimensions. So I think,
The size
So I think your contract even includes that now, a little
Isn't
sheet.
there a writer, the measurements?
Measurements.
Disclaimer.
Right,
Yeah.
exactly.
I would advise everybody.
But
Yeah.
I tell you what, that it is a good form to use because
Yeah, that was a good change, I think.
that form, yeah, those forms are there to protect you. Use them. Yeah. Any other horror stories? No.
Oh, there's plenty of
We
them.
could go on.
Yeah, we got plenty of those. And we do want to know what is causing you all sleepless nights, you know.
If it's something we can help with, we will try. Yeah, I wish we could.
Inspections. Oh, I'm glad somebody brought that up. Yeah,
Oh, man,
inspections.
that's a quagmire right there.
All right. Few things and because I did have a question for you guys on this. Because, you know, inspections always affect, you know, can we actually do an adjustment on the price on that and how you handle that? And it always becomes this, what will the lender let us do? What will they not let us do? You know, make sure you ask before you finalize that and because inspection reports don't always get to the title companies. We rarely see that, but we do deal with the consequences of it. So make sure we are kept in the loop with those.
We don't need the inspection report.
But we need to know what the result is. And we've recently had a new one. Karen, why don't you fill everybody in?
Okay, so, well, back on the inspection notice. If you guys do an inspection notice and there's gonna be some kind of a credit and there's a lender involved, at the time you're doing your inspection notice and response, if it's determined that the seller is gonna give the buyer a credit, go ahead and do an amendment at that time with the inspection notice, because most lenders, we don't want to send a lender an inspection notice with a credit. We want an amendment that says seller to give buyer a credit for closing costs and prepaids. Because once you send an inspection notice to a lender, you can't unsend it. Once they see it and they think there's something wrong, you've opened up a can of worms that most of us don't want to have to go down. So if you're doing that inspection notice at that same time, have that amendment that says the seller's giving the buyer credit for closing costs and prepaids for whatever. That way we can send that to the lender when we're working on the CDs. And then because they have to make sure the appraisal, they don't have to redo the appraisal. I mean, there's a lot of things that go on with those credits. So just kind of keep that in mind so that we're not at the last minute. I can't get the CD approved. I can't do the settlement statement. We're holding up closing because the lender has to send it back through underwriting, but all we have is an inspection notice. And if I send that to a lender, I can't take it back. And once they see it. Yeah, well, that's I mean, if it's a big thing, that's when we need to talk, you need to talk to the lender ahead of time or see if a price reduction is better, the better way to go about that for the lender and the loan that they're doing. I mean, we don't always know that. I just know if it's a $200 credit or a $500 credit, usually those little, you know, they're a lot of paperwork for, you know, but you still have to do it. It's just, you know, at the last minute, that's when we don't like to find out about it.
So if the price of the home is reduced, do you have to redo the title commitment?
We just have to change
We have
the
to
first
change the
page.
front page, correct?
Yeah. So that's, you know, yeah, if there's a bill, if we can pay a bill, yeah. Yeah, if it's something like that. And in fact, we kind of prefer to do that because then we know it gets paid. You know, So if there's a bill, we can charge it on the seller's side. Like, good example, good point. And then it's just taken care of. Then we don't have to worry about it. So, yeah. Now, something that just came up yesterday on one of my closings, some of the condo complexes are now starting to require inspections, not the inspections that you guys are ordering for your clients, but they go in and inspect the property to see if there's fogged windows or things that they want repaired.
Yeah, that's what we said. What?
Yes.
Yeah.
Southwood Shores is a great example with windows. Now, right. Now,
Resale inspection.
yeah. Now, yeah. So, but Southwood Shores, the way they do it, they won't, when we order a resale certificate, they'll say to us, well, they have fogged windows. We won't release the resale certificate until the windows get fixed or until we have payment. And then I don't know what they do, if they hire it done or I don't. Okay. So, yeah. So that's great because then everybody knows about it and they won't give us the resale package until that's done, and that's fine. What happened on this other one, and this is a new scenario, when they sent us it's Indian Point, when they sent us the resale packet, they included in with the invoices notice that certain things needed to be fixed on the unit at the seller's expense. Well, we typically don't send invoices when we forward the resale certificates. We're sending them to the buyer, the listing agent, the buyer agent, and the lender. We pull out the invoices because that gets confusing to people and they think, oh, I need to pay this, or they are, it has private information on it. A lot of times the invoices will have seller information on it that we can't disseminate because it's not public information, address, email, phone number, stuff like that. So we pull out the invoices a lot of times and forward everything else. Well, we didn't realize that there was this letter in there, nor should it have been sent to us because it's not our responsibility. But there was this letter that they had this list of things that they needed fixed by the seller, that they were saying your decks and bylaws require these things to be fixed. Band boards on the boat slip, a fogged window, some painting of something. I mean, whatever. But yeah, this is yours. Yeah, it just came up. Yeah. So, so as soon as we realized all of this, we said to the agent, hey, your seller needs to take, we got this. What do we do with this? But they never sent it to the seller. So, yeah, it is yours, Amber. It is yours. So, I'm just bringing this up because this is a new thing, and it's not a good thing because it's not that we're not going to get in the middle of that. I mean, that's not up to us to tell the seller that they have to do repairs. It's not up to the buyer to decide. I mean, this has contract ramifications on it, possibly.
Closing, if you're 5 days out closing, you're not going to get windows done.
Right.
Like I mean, you just hold back funds to pay for them to satisfy the HOA to get the retail.
That's going to go down a slippery slope. That's what the association said. So, I mean, and this is a brand new thing that they just started. So, because the last one I had didn't come up. Yeah, a lot of Oh, well, if we're doing an escrow agreement, then that, if the lender agrees to allowing an escrow,
But it's on the seller side.
it is, but it still affects the lender. Yeah, lenders have to. Right, I mean, the only reason this, the association should have let the seller know that they wanted these things done.
What, yeah.
They require
They
the seller.
require the seller.
And they also require us to send them we also have to show them our receipts and disbursements.
Yeah.
And they can audit us at any time if they think that we were doing something on the side that they weren't aware of.
Right.
They can come and say, we want to see your accounting of this file. And if they see money held back that they didn't know about or agree to, then we're all in trouble. So it's a slippery slope. So
I'm saying I had a situation last month where the management company sent my buyer when I slip agreement to sign.
yeah,
Okay.
Didn't put in the doc or slip or anything.
yeah,
And my guy's like, I'm not sending the book.
Yep.
Got to fill it in.
well, there's a particular management company around here that does not fill out any of the paperwork on the boat slip stuff. Yeah, and so if I feel like I have confident information and I've asked you guys, is this the boat slip? And I asked the seller at closing and I asked the buyer at closing. You guys hear me at closing. I'm like, this is your boat slip that we're, this is the number, I'm a little obsessive about it, but then I'm filling it in for them before they sign it, which I shouldn't be doing, but in order to get it done, that's what I'm doing. Yes. Yes. Okay, you could say it that way. I might use a different word, but yes, you could say busy. Oh, yeah, but that doesn't work. I tried. Yeah.
All right,
Professional services.
We're gonna, because we've gone for an hour, so we're gonna go through the exceptions real quick. That's the part that you guys look at all the time because you're looking for your declarations, your restrictions, your well agreement, your septic agreement, your driveway agreement, you name it, that's gonna be. And just so you know, exceptions means that the title company does not insure because these things exist. They're there and we can't do anything about them being there. So if your client doesn't like the well agreement and it's already there, we can't really do much about that. You would need to, and this is where the prerogative of the attorney comes around. So well agreements, septic agreements, driveway agreements, all those things are legal documents and need to come through legal counsel. We prepare those through the Cisar Law Office at our request, and then we provide it to you. We do not get in the middle of a dispute, and the Cisar law firm is not representing any of the parties in the transaction. But feel free to use any attorney that your clients want. Okay, it is simply, we do it as a courtesy, but your clients have the ability to choose whoever they want to work with, any legal, and I work with every attorney here in the area, have very good relationship with all of them. So and you'll see if I refer an attorney, my husband is not on that list because I will refer you to the other real estate attorneys in the area. Tim Cisar represents Arrowhead Title. That's it. Okay. What questions do you have about what's shown under the exceptions page? This is a very standard 4 seasons, very long, but actually not very scary. So that is, how long it is doesn't make it scary. The one thing we don't know is your client says, hey, I want rentals. Can I rent this property out for VRBO and things like that? We cannot answer those kind of questions, unfortunately. Okay. That is not a title company type questions. We can provide you with copies of everything that is of record, but we cannot answer that kind of question. Do you guys have questions on what is shown under exceptions normally?
With the land sale increasing,
Yes.
people come,
Yes.
would recommend to the like on that.
Yeah. Okay. The mineral rights, if we find them, this is again based on a 45, 50-year search. If there are exclusions as to mineral rights, they will actually be specifically named. We do have one that says, hey, we don't go back to the 1890s to see if there's something out there, unless it's commercial property, and sometimes we do. As far, I can send you all a list. You know, you guys know attorneys that you like to work with. And as long as they are real estate attorneys, we can work with any of them. So, and I would highly, as you get more sophisticated, if you get someone who wants to build or is looking for a particular project they want to do, you know, I would recommend that they sit down with an attorney and get the legal advice, taking that off your shoulders, really. And Carol, I think, has the list of attorneys that we work with. She can give that to you.
Does anybody have any questions on what exceptions are or what to be looking for in these? I mean, it's basically just a list of what's already recorded for that property. So,
and you guys get that mountain of paperwork that goes to your, you know, your
all the
buyer.
copies of everything. One thing I am going to say about exceptions, if you ever look through them on our commitments, we always put like deeds of trust and things at the bottom, at the very end. So if you ever see, you know, we've had a requirement on there to release a deed of trust and your seller insists, I've never had a loan on this place. If you flip back to the exceptions, this is where we put our detail of what is recorded. If you see the deed of trust with US Bank and then a name you don't recognize, that means it was a prior owner or a big time screw up or something as far as that recording. We still have to deal with it because it's there. But if your seller's saying, no, I don't have a payoff, that's where you're gonna see, oh yeah, they really don't. It's somebody else. Because that's the first place I look when they say, no, I don't have a payoff. And I'm like, but there's a deed of trust. Oh, but wait, let me see who it was with, you know? So that's where you're gonna find that on our commitments.
We try to give you a heads up if there's something of major concern that's going to require something in specific, you know, or unusual. So, all right, I'm gonna,
Any questions?
yeah.
Anything we didn't really talk about beneficiary deeds. Do you guys have questions about beneficiary deeds? We get that a lot. A beneficiary deed is what you would think of as a transfer on death, kind of. A lot of people say, oh, I want to transfer on death, kind of like your car title, but it's for real estate. So it's something that we can, for your buyer, if they want a beneficiary deed, we can have it prepared and signed at closing and recorded so that they name who they want it to go to after they die. And then they can avoid probate in a lot of cases.
And it is part of estate planning, and it is also a legal document. So it is, it does come through legal counsel as what we're just preparing
But
for you.
it's something,
Right.
we have it signed and recorded at closing. But if your buyer asks you about that, just let the title company know that they're gonna want that so we can get the information and get it prepared and have it ready to go for them. So it's nothing,
And it's usually done in conjunction with an attorney. And
yeah.
I don't think title companies do that outside of.
We just help
prerogative.
facilitate it and then get it signed and recorded. But it's not something that, it's not a scare, sometimes people get, well, they're asking about this and, and likewise, if you ever see a beneficiary deed listed on the exceptions, usually that has no effect on your closing once we have the deed from the vested owner to the new owner. It's just there. We're just saying it's there. Unless there's something weird and somebody died and, it's not the right people or whatever, so.
If your seller is deceased, there are myriad of ways that could be, who has authority to sign now is the question you'll be facing. And that just have your title company look, because it just depends on what they had planned in advance before they died, as to who can sign.
So that happens like when you're under contract with the one that passes away.
Okay.
Any
It all depends on how
They
it was
owned
owned before. If you're talking about husband and wife and one of them dies, most of the case, the surviving spouse will have the right to sell it as long as it was owned as husband and wife.
They were both entitled. And you have the driving spouse sign, and then we'll put a recital on the deed that explains what happened to the other person. So we'd need a date of death. Sometimes we need a death certificate, but usually we just need the date of death.
We try to be sensitive to the scenario, If they owned it in a trust, or the person who died was the sole owner, you really have to talk to your title company and say, okay, what do we do now? If they had no planning and it just died, then it will take some time, because you'll have to open an estate. So. Right.
Any other questions?
Well, did we entertain you guys long enough? Too long.
Was it helpful? I mean, there's so many things we could go on, but